Very good evening, all of you. Warm welcome for this session on PDPA by Mr. Naavi. It's my honor and privilege to welcome all of you as well as introduce our main speaker, Mr. Naavi, for this session. I think Mr. Naavi doesn't need any introduction by me to all of us, but still very quickly to say, as we know, is the one who is spearheading the privacy movement and currently the chairman of FDPPI, Foundation of Data Protection Professionals in India. And he is also having this FDPPI, which is a private company limited by guarantees registered under Section 8 of the Companies Act. Mr. Naavi, a very renowned person in the area of cyber laws in India, pioneer, I would say, and has also started the Cyber Law College. And currently, as part of FDPPI, where all of us are involved, associated with him, he conducts lots of organizes seminars, presentations, courses on privacy-related stuff, whether it is India law or global laws and so on. Would be quite interesting to listen to him. And last point, but not least, I'm sure all of you in the call would be aware of that Mr. Naavi was also invited by the Joint Parliamentary Committee on Pdpv, which they are currently looking at, to envisage his feedback, his thoughts, and he represented and presented his views during the August 2020 last year, and it was well received by all the people who were part of that from the Parliament. With this, I would hand over the floor to Mr. Naavi, and let's all listen to him. And as usual, kindly go on mute. And if there is any question, obviously you can unmute and ask question with Mr. Naavi. Mr. Naavi, thank you very much. Floor is yours. Thank you.
Yeah. Good evening, friends. Of course, today I think a lot of you are a bit tired after the examination. In fact, I thought most of you would take it in the morning session itself because this examination was open from 6 o'clock, but I think most of you took it in the afternoon. So I'm sure some of you are still relaxing after attending the examination. Maybe some more, therefore, will join a little later. But still, I wanted to have this discussion today, specifically because today is a very important day for FDPPI, because for the first time, we can confidently say that we have now a set of people who can actually go beyond merely, let us say, understanding the law to actually conducting a data audit, which is as per the expectations of the Personal Data Protection Bill. So since we completed this Module A examination today, in which at least about 24 people have taken the examination today, and I'm sure that most of them will be passing the cutoff marks. Of course, we are having two kinds of cutoff, that is one for the consultants and one for the auditors. And by the end of today, we will have a group of people who have not only completed this Module A, but have earlier passed Module I and Module G. So those people who have completed all these three modules are the people who are a new category of data protection professionals in India. And none of the other certifications globally recognized or otherwise have ever attempted this kind of focused discussion on the Indian law. And therefore, I thought that we have to actually commemorate today's situation by discussing about the Personal Data Protection Act from the perspective of HR professionals. For two reasons. One, HR professionals themselves are actually data protection professionals for the employees. So they have a lot of things to learn about data protection. Plus, of course, they will be actually recruiting people who are called data protection officers in their respective organizations. So I thought that we need to actually take the trouble of making them aware of Personal Data Protection Act as it will come through. Just as CISO should know about PDPA, or CTO should know about PDPA, because they will be aspiring to be the DPO. So I thought that it is essential to bring the HR people also into the group of DPO aspirants by discussing with them and making them understand the implications of the Personal Data Protection Act as it is emerging. Of course, today we are talking of Personal Data Protection Bill 2019, which is the version which is there in the Parliament, which was discussed by the Joint Parliamentary Committee, and certain changes they have perhaps they envisaged. And though the newspaper report says that there will be 89 amendments or something like that, I don't think we should get too much alarmed about the number of amendments, because most of the amendments would be minor amendments, and there will not be change in the protection principles, data protection principles. There will be certain procedural changes and other things. So what we are trying to do is to discuss Personal Data Protection Bill as it exists presently. And then, of course, we will have other sessions in which if the actual act becomes slightly different because of the additions, we will cover it in a separate session. But those of you with whom I have been discussing are fully aware of this concept of privacy. But for the sake of the few who might not have had earlier an opportunity to look at Pdpv in greater detail, I would like to say that the principal objective of this Personal Data Protection Bill, which is going to be the PDPA, the Personal Data Protection Act, it may be called PDPA 2021 or whatever name. The principal objective is actually to protect the privacy rights of Indian citizens, because this is what Supreme Court of India said in the Puttaswamy case. Because they said privacy is a fundamental right in India, and every one of us, all companies, government, everybody has to be committed to protecting this privacy. That is always in the back. It is the foundation of this PDPA. So whenever we get into doubt about interpretation of any particular provision of the Act, we must remember that the interpretation has to be based on the ultimate objective of the legislation, which is to protect the privacy of the individual. It is not to protect the data, it is to protect the privacy of the person. That is why we give a lot of emphasis to the identification of harm to an individual by virtue of any data processing which we adopt, and try to ensure that that data processing measures which we adopt do not create harm to the data principle or mitigate the harm to the data principle. So that is the principal objective of the Act as it stands now. But we also know that Supreme Court very conveniently did not go into actually giving a good definition of privacy, because otherwise we all think, and even Supreme Court in cross references have said that privacy is a right to be left alone. It is the right of an individual to be left alone. But this to be left alone is not in terms of physical kind of a segregation. It is actually a mental feeling a person should have, that he should mentally feel free, that nobody is interfering with his kind of existence. So this is something which is little abstract as far as the IT activities are concerned. So many of us, we always keep getting a doubt, why is this human rights concept of privacy is being hoisted as a responsibility for an IT company? What is this information or data has to do with the privacy? So when we interpret the law, we are now come to the conclusion that what the court or privacy activists expect out of us, the IT companies, is that we need to protect the personal data of the individuals in a manner he would like it to be protected. That is, the use and the disclosure of personal data should be as per the choice of the individual. So ultimately, what all we are doing is to provide a right of self-determination to the data principal. Whenever we collect the personal data will be collected as per the wishes of the data principal, and then it will be used accordingly as per his wishes. This is what is something which we call as the consent mechanism. Of course, HR professionals will sometimes get a doubt. Why is it that Pdpv is relevant for me? It's a legal issue. Can it not be handled by the corporate counsel? Or is it something to be handled by somebody who is designated as the chief compliance officer or CISO or the CTO? It's a legitimate question, because most of the time HR professionals are too preoccupied with recruitment, so background verifications, and maybe some resignations, attrition. Seldom the majority of HR professionals get time to think more than this attrition rate, new say CVs landing on their table, and so on. So when we are saying that no, HR professionals should also be brought into this discussion of Pdpv, the question comes on, why is it relevant? One of the things which I would like to highlight to the HR people, this is, of course, some of you are not HR persons, you are already in the data protection, but this thought process is important for all of us, because within your own organization, you need to actually have an interaction with your HR people. And in a way, whatever I'm discussing now, you should be able to have an internal presentation to your HR team and convey our thoughts of why Pdpv is relevant to them. In fact, some of you should actually take it as a follow-up of this, repeat this kind of a presentation with your HR people, because not all of them would like to come and attend a webinar like this on a Sunday evening. They are enjoying their weekend. So catch them as part of their activities of day-to-day type, and then try to spend half an hour, 45 minutes to explain these concepts. Because HR persons are the people managers. We all know that information security also is never an IT function alone. Today we are talking of techno-legal compliance, so law is into our compliance, but ultimately people are the most crucial elements of any compliance. So all in all compliance, technology is in the forefront, but legal is driving them, and then it is the people who have to work whatever policies we define or whatever tools we give, ultimately people have to use. So people managers are critical to any activity of information security, including compliance of data protection laws. So that is important. And therefore, when the new act comes, for example, in the next month or so, suddenly there will be a rush for recruiting people who may be titled as data protection officers. So naturally, the question will be posed to the HR in charge. First of all, to draft a job specification, and secondly, to identify if any of the existing persons in the organization can be redesignated as the DPO. So this is one of the first tasks I feel HR persons will be confronting as soon as the parliament passes this legislation. So that is why they need to know what is Pdpv, because to draw up a job specification for recruiting a DPO, they need to understand what is the expectation of the law from the DPO. Then they can think whether the DPO should be external person or we can elevate any of the existing persons. When I use the word elevation, that itself the HR person has to decide. Are we talking of elevating CISO to DPO position, or DPO is somebody who is much below the CISO? This kind of organizational fixing of the roles and their responsibilities is also a key responsibility in which the HR person has to contribute to the CEO and design how the structure has to be decided for this new designation. See, in the case of GDPR-oriented companies, already there have been people who have been designated as DPOs, but GDPR gave an option for external DPO, so many companies opted for having an external DPO so that they did not enter into any kind of a clash of whether the CTO will get upset if CISO is promoted, or CISO will get upset if CTO is promoted. They simply went for an external DPO, and it was comfortable as far as the HR issues were concerned. But Indian law expects the DPO to be an employee, so the HR person will have to ultimately determine not only who is best suited to be an employee DPO, but also if there is any conflict which is arising, he will be the person who has to bear the responsibility for resolving it. So therefore, HR people need to look at the DPO position of what should be the skills required, where should he be placed, and so on. Okay. Then if an external DPO is still considered necessary because you don't have talents within the organization, then you have to look at a hybrid model where you designate an internal person as a DPO, but give him support with an external consultant who will perhaps, even if necessary, sit on the data protection committee and participate closely with the operations of the DPO. But for legal purposes, DPO will still be the employee of an organization. A thought will always come that if you are talking of a DPO who is in a position which is even higher than CISO or CTO, because we expect that this person should report directly to the board, then could a HR professional himself or herself aspire to be a DPO is also a question which HR persons should ask for themselves. If this is a coveted position, definitely they should look at the possibility. And just as a lawyer becomes a DPO or a purely technical person becomes a DPO, though this is a techno-legal requirement, a HR person also is well perhaps positioned to become a DPO, provided he acquires whatever additional knowledge and skills are required. Other than this, one thing which HR persons should remember is that they are required to manage the privacy of their employees. Therefore, even if it is a manufacturing company in which there is not much of personal data of customers, unlike in a, let us say, e-commerce company or something like that, there are manufacturing companies where there are thousands of employees, and there are IT companies also where the number of employees will be 10,000, 50,000 or a lakh, which is substantial, and they all are presently under the management of the HR department. Therefore, the HR person is already having a lot of privacy related responsibilities with the employees. Now, handling the employee privacy is really not simple, though he is an internal person as against an external person, because many of the time problems will be more from employees who are internal, because there will be clash of, you can say, between the employee and their management. Sometimes it leads to a person quitting the employment, he becomes a disgruntled employee. So he will be knowing everything about the company, and then if he drops a complaint to the Data Protection Authority and turns a rogue, then the company is finished, because none of the companies may say 100% they are all compliant with every law. There will always be some weaknesses here and there. So if this person either becomes a genuine whistleblower or he becomes a malicious, say, rogue employee, then the company will be facing a lot of trouble. So the HR manager should ensure that people remain properly motivated and no privacy related disgruntlement comes within the organization. Therefore, I feel that HR manager has a lot to worry about being a DPO of the employees. And the work from home scenario has not improved the situation. It has actually more complicated it. And therefore, that is another reason why HR persons are concerned. Then most of the information which the HR persons handle in terms of background information, etc., we are talking of financial information and health information. Because you do background verification, you pay salary to the directly to the bank account, and then you do medical examination. So what we generally call as sensitive personal information is the one which is normally handled by the HR people. So that is something which increases their responsibility. And sometimes they also issue confidential opinion about ex-employees when the HR manager of another organization sends a request. And that is a time when perhaps you will be worried about how much you can disclose about the person. And we also had some time back, I don't know how, only the industry people have to tell me how much you are actually using. NASSCOM had a registry of employees and expected certain information about employees to be posted there. In the current context of privacy, anything you post into this NASSCOM register will have to be vetted for privacy related issues. I don't know whether many of you would have actually discontinued the use of this particular NASSCOM registry. But if you want to continue to do it, or if you want to send references to other companies about new recruitments and other things, then you have to look for what the Act says in such situations. Okay. And another problem which HR people face is about rejected candidates. That is, even before you can actually get an NDA signed, you would have collected all the sensitive personal information from the prospective employee. But at the end of it, if you don't recruit him, then what will happen to that information? Should you immediately delete it to the extent that you have to forget that person, or you should archive it so that next month the same person will not apply through another perhaps branch or something like that, and waste your time in screening him once again. So these are policy issues. Most of the organizations may say a person should not reapply within the next 3 months, 6 months, 1 year, or whatever is that. So to identify whether a person is applying once again, some companies would like to actually retain the data of even rejected candidates to some extent. And then sometimes the reasons for rejection also becomes important. It has to be actually documented for what we may call as the legitimate interest of the organization itself. But more than the rejected candidates, it is the terminated candidates or retiring candidates who create a problem. If you want to terminate a person, then the reasons for termination will have to be properly documented. Anytime later, even after a year or two, the person may file a case against the company about wrongful termination. So the question of deleting the data of the person immediately after his termination or retirement does not arise at all. In fact, there is a legitimate interest for retaining that information for a reasonable time until any consequences of legal issues arising is taken care of. So handling the personal information of rejected candidates and terminated candidates is a special, you can say, problem area for the HR persons. Then in terms of assessment of performance for promotion. In fact, many times, because I also used to be discussing about cyber crimes within an organization, I have been suggesting to many companies that they should actually, this was all prior to this last 3-4 years when privacy became a very important concern. I used to suggest to the companies that they should have a mapping of the deviant behavior of the employees. Today, if I say that in a company, they will get aghast and they may think that I'm a devil kind of a person suggesting that. But my idea was that we should be able to assess the organizational employees, and we should be able to decide in terms of security risk, is any of the employees are having a deviant behavior risk which may culminate in any cyber crimes on a future date. And I used to suggest that we need to classify them as green employees, or say yellow, and then maybe red, who are not to be considered for sensitive positions at higher levels. In fact, in this information security department, persons with that red tag cannot be employed. This was the kind of suggestions which we were discussing, and I don't think that logic has gone off now. But still, at the time when we are talking of privacy, if I suggest such kind of a profiling, then the risk of an employee getting really upset and perhaps take on the company stating that this is a very undesirable practice is very, very high. So maybe in a different context with the HR persons, we can discuss about this. Otherwise, what we used to suggest was that you have, say, something like a leadership training or something like that, where you try to assess persons about their behavioral, say, it is while assessing the behavioral skills, you also assess behavioral traits which are negative in nature, and that has to be recorded. Of course, it's a very dangerous situation. If any wrong assessment is made, then it will affect the future career of the person. So it is normally done by professionals, not by the HR managers, but with the external persons. So such things were common HR practices a few years back, at least when we were there in the industry. In fact, whenever we were interviewed for senior positions, companies used to actually have a HR interview with an external behavioral consultant. Okay, nothing to do with salary or functional expertise, but only on the behavioral suitability for a particular position. Now, in the current scenario, this has become a very difficult issue to be handled in terms of HR. Additionally, we have this whistleblower policies, sanctions for non-compliance. This will be issues which the HR manager has to sort out. We have discussed this concept of consent manager under the Pdpv. You know, in Pdpv, there is a provision that an organization can do a business called consent manager. And this consent manager will represent the data principals as a group and deal with the data fiduciaries, not only at the time of collection of personal information, but maybe subsequently when the rights are to be exercised and so on. So consent manager more or less becomes like a social activist kind of a organization. Okay, if they they have got a role to play, because we know consent and notice is a difficult thing. Many times the data subjects don't understand what is the notice, and therefore consent manager is there. Many people have asked me that whether we can, whether the HR manager can himself be called a consent manager for the employees. But this consent manager concept is not meant for the company's own HR management system. It is actually meant for third parties, for example, customers of e-commerce companies or something like that. But this is another aspect where there is a direct relationship between HR skills and this role which has come because of the DPO. In terms of job opportunities for HR people, maybe working inside a consent manager is a new job opportunity which they can think of. So these are some of the things which come to my mind when I think of Pdpv for the HR persons. That is why I say that the knowledge of Pdpv is essential for HR professionals for harnessing new opportunities for themselves and for identifying appropriate persons for DPO position. And that is required because that is what they are supposed to do as a justice of their profession. and for managing the compliance of the employees themselves. So this is the relevance of PDPV for HR professionals, which is most critical. Look at HR professional as an undesignated DPO for at least for the employees. So if you tell this to your HR manager, then they will understand that they also need to look at the PDPV in as much seriousness as a person who wants to be an auditor, who wants to be a CISO, protecting the personal data, the amount of effort he takes to understand PDPV. Okay. In fact, I want every HR person to be a DPO himself before he appoints a DPO. Sometimes I have commented this also some time back, if some of you remember, when State Bank of India issued a DPO appointment notice and another company, Tech Mahindra or something, released. I did make a comment that the job specification itself was not properly done. I don't want to make such comments, but still, that is what happens if the HR person does not know what it is to be a DPO. Then only he will get some idea of how to specify the requirements and perhaps conduct an interview and even select. So this is the background. Beyond this, we have to get back into the actual PDPV. And if I look at the people who are there in today's meeting, a lot of you have been exposed to PDPV. So I will try to go little fast on this, and maybe I will come back with your questions, okay? Otherwise, it will be a repetition to most of you. So the perspective of PDPV, which we have to look at, is one from the applicability angle, then the consequence. Yeah.
Ramesh here. Somebody is waiting outside. Can you please admit them? I'm sorry. Otherwise, you give me the co-host because I was logged out and logged in.
Okay. Okay.
Thank you.
I will again make you.
Yeah. Thanks, sir. Thank you. Sorry.
Okay.
Yeah.
Just okay.
Great, sir.
Yeah. Okay. So when we talk of PDPV, applicability, consequences of non-compliance, then obligations. Now, when we look at obligations from the corporate side, I would like to make the distinction of what are the obligations of the top management, what are the obligations of the compliance department, what are the obligations of the technology department, and then come to the obligations of the HR. In fact, those of you who have discussed PDPSI know that these are the different ways we are segregating the duties of the internal departments for the purpose of DTS evaluation. And for those of you who do not know what is DTS, DTS is the data trust score, which the Indian law expects us to stamp an organization with, and showing what is the level of compliance in a particular organization. So I may say DTS of X company is 60, another DTS of Y company is 40. That will be put on the balance sheet or on the website, and it becomes an external information which affects the reputation of the organization as a whole. That is DTS. For evaluating the DTS under the Personal Data Protection Standard of India, PDPSI, we have identified this responsibility groupings under different management and technical and legal, etc., different corporate responsibility groups. And maybe that is something which we have to look at in understanding the PDPV, use a kind of classification which is required. Normally, when we look at an act, we look at chapters, chapter 1 to chapter 10 kind of a thing. So instead of that, I'm looking at it as what is relevant for management, what is relevant for HR, etc. Okay. So applicability, the first thing is whether this act is applicable to what type of organizations, both government and non-government are coming under this applicability. Indian and non-Indian companies are coming under this applicability. Then in terms of types of data, personal data comes under the act. Non-personal data is completely outside this particular act. And the difference between personal data and non-personal data is defined in the act itself. because the act shows what is how to classify a personal data. Then we have the types of data principles. Basically, it applies to the natural persons, individuals. It does not apply to the data of non-natural persons. Okay, and even they should be, in my opinion, living natural persons. See, many times we get the difficulty of understanding about an email. See, email address is considered a personal information, but email address can be a business email or a personal email. In fact, that will be an eternal question in the privacy area, whether business email is considered also as a personal information. For example, if I say Vijay Shankar at Cognizant or something like that, then is it a business email or is it a personal email? This debate will continue to rage for a long time. There are many GDPR supervisory authorities who will consider anything which contains the name as personal information, though the business email, that is Vijay Shankar at Cognizant or something like that, will be used only for the work related to Cognizant, let us say. Okay. In fact, it may be entirely a business purpose email, but somebody says the VIGAYA or something like that is a representation of an individual. We know in technology that VIGAYA has no meaning except zeros and ones, which the computer looks at. So it is only the human who is reading it and say, oh, Vijaya means a person should be there. But actually, there is nothing like that. Vijaya can be a business organization. Vijaya can be something else. Kailash may be a personal name. It can be the name of the country, which Nitin, what is that? Nityananda is owning. So anything is a combination which has got no meaning as far as computer is concerned. For the computer, everything is zeros and ones. It is only the human mind which ascribes the meaning to the particular data. So distinction between a business email and a personal email is a tough decision. And maybe as we go in the future, the companies will have to make a change in providing email addresses to their employees. Today, they are all giving email addresses in personal names. If I say Vijay Shankar, they'll say Vijay.Shankar or something like that. There will be several persons with several similar names, but I don't know whether this system itself requires a change if you want to segregate the business email from the personal email. So this is one of the things which you have to worry later on. Otherwise, now this particular PDPA applies to any type of organization for personal data, not for anonymized or non-personal data. Anonymized data refers to data which was once personal, but the identity parameters of the personal data have been so completely removed that it is not possible for anybody to re-identify them. That is the anonymized data. In between, there is a category called de-identified data. De-identified data will continue to be called personal data. Pseudonymized data, where we replace identity parameters with something else, that also continues to be personal data. Only if data is permanently made unidentifiable to any individual, that is called anonymized data. Other than this, all corporate data falls under non-personal data. So that is the applicability. If that information, that is data, is collected, disclosed, shared, or processed in India, then this act will be applicable. This activity can be done either by a government or by a private company. The companies or the government may be Indian or outside India. So a body corporate incorporated in India is coming under the applicability of PDPA. Sometimes these companies will not be handling the personal data of Indians, they will be handling the personal data of foreigners. Now, as I told you, the original objective of this act was to protect the privacy of Indian citizens. In that context, the privacy of foreign citizens is not our cup of tea. So therefore, it should not be necessary for us to work on that. But because the company is established in India, the law automatically becomes applicable to them. So our law has found a way out of this by saying that if you are processing only foreigners' data, you want an exemption from PDPA, we will be able to give it to you by way of a notification. But otherwise, in principle, any company incorporated in India will automatically come under the laws passed by the Indian Parliament. Now, for entities not present in India, they will become liable under PDPA only if they are processing personal data connected with business carried on India, or they are doing a profiling activity of Indians. This is something which is universally accepted even under GDPR. In terms of penalties, we should remember that there is a 2% of global turnover, 5 crores, whichever is higher. This is one kind of penalties which is applicable for not only data breach situations, but also for non-registration. Under Indian law, certain companies need to be registered, and if that is not registered, then that itself may result in up to 5 crores of penalty. Then DPO not being appointed, or a DPIA or an annual audit not being conducted. These are also non-compliance issues for which a substantial fine of up to 5 crores can be imposed. That is why simple things such as appointment of DPO becomes very important. Okay. The second category of penalties is 15 crores. This is applicable for violations of data protection principles, the provision of rights to the data principles, security, cross-border transfer, and so on. Other than that, there is a per day fine for not responding to the data protection authorities' requests for information and such other things. Government bodies, of course, will have a maximum of 5 crores. There is no turnover criteria for government bodies. There is one element on which criminal offense is also recognized, which is re-identification of de-identification, for which there could be a 3 years imprisonment. This is unauthorized re-identification of de-identified information. Okay, when we are discussing, we use the terminology called data fiduciaries and data principals, data processors, consent managers. There is a category called social media intermediaries, which was also being referred to recently when the government came up with the Section 79 guidelines. Then we have entities called Data Protection Authority, Adjudicator, Appellate Authority, and so on. If there are any questions, we'll take on that. Similarly, in terms of data, we classify data for personal data protection purposes, not like what we do for an ISMS system, where we say perhaps confidential or whatever other way, public, private, you can use. Here, we need to classify data as personal and non-personal, anonymized and de-identified or pseudonymized, sensitive or critical, children data or employee data, something like that. This kind of classification is different from what is there for the ISMS, and therefore we need to actually have a new data classification system. Okay, there are certain rights which the data principles are expected to be protected with by the organization, such as a right to be able to query whether his personal data is being processed by the company. If so, what kind of processing is being done? That is the right of confirmation and access, right to correction if the data is not correct, right to erasure if the data is no longer required, right to withdraw consent if the consent has already been given, and right to port the data along with the profile, etc., to another company or to the person back to himself, and then right to forget, which is a permanent deletion of all identity of the data principal with that company, to the extent that tomorrow if you ask him, do you know this particular person's information, the company should be able to say, in my records, I don't know anything about this person. That is the kind of right to forget, which is to be protected, given. All these rights can be enjoyed by the employees. Please remember, that is where, how can we give a right to forget to an employee, even after his ceasing to be an employee is a question which we need to address. That is where we have to look at the legitimate interest of the organization and arrive at a balance, and that balance should most probably be worked through proper policies. Okay. Then the principles of data processing, most of you are aware. So it is should be processing should be done only for lawful purpose. A notice has to be given, and consent has to be obtained, and we should ensure that the data is collected only for the limited purpose, for the purpose for which it is meant, and not for any other purposes. Then collection of data should be only what is relevant for the purpose. The data quality has to be maintained. That is, no errors should be there. Retention should be only for the period for which it is required. And then, of course, the data fiduciary should be accountable for meeting all these principles. Consent is an important aspect. Free consent should be there, capable of being withdrawn, to be well informed, that is the notice. Then specific consent should be taken in case of sensitive information, which we can call as explicit consent, specific for the purpose, and there should be no special conditions to be imposed on the delivery of any service. Indian consent is clearly a consent, a contract, and the notice is the offer, and the acceptance is through the consent. But the burden of proof that a consent has been obtained lies with the data fiduciary. And there is only one good thing which has been done in Indian this thing, that is, if a person wants to withdraw the consent for insufficient reason, then if there is a cost for the company in allowing that withdrawal of the consent, that cost can be recovered from the data principle. So that irresponsible withdrawals of consent is to some extent not allowed without a cost on the person. Okay. Now, though the Act says so many things to be done, we must remember that there are a number of exemptions. In fact, the exemptions are there to the government agency because of national interest, law enforcement agency because of the investigative purposes. Then courts definitely must be given an exemption. Then personal use for domestic purposes is again given exemption. Journalistic or research, some exemptions are there. Foreign citizens, I already told you, exemptions can be given. As far as small entities is concerned, for the purpose of manual processing, some concessions are given. In addition, innovative companies who wants to test out new processes can avail of what is called a sandbox provision. So there is a lot of exemptions available. There has been a lot of criticism on this national interest case, but the exemption which the government can take under national interest is limited to what is available under the Article 19(2) of the Constitution. So government has actually limited its power to claim exceptions. It is available only where the sovereignty or integrity of India, security of state, friendly relations, such reasons, not arbitrarily for any other aspect. Apart from this total exemption from consent is available in certain cases, which again the state has a share of it when it has to give a service to the benefit of the citizens, or it's required under law, court's judgment, medical emergency, and disaster. But what is more important perhaps is the exemptions available for employment purposes. There is a permission under Indian law for processing without consent. This is only for processing without consent. And rights, transparency, and accountability is also exempted, except security. Security is still available. Rest of the things are exempted in employment scenario. And where did I lose? Okay, this was employment. So processing for recruitment purpose, then termination purpose, provision of service benefits, attendance verification, performance assessment. In all these cases, exemptions are available. And there is also a clause which says that where it involves disproportionate effort, one can try to seek exemption, but one has to be very careful in availing this kind of a benefit. But remember, the Act has recognized the need for certain exemptions. It is not very arbitrary like GDPR. Then other than this, for business context, reasonable purposes are also defined for which processing without consent is possible. It could be legitimate interest, prevention of fraud, information security, credit rating, public interest, and where there is a reasonable expectation that a consent may not be required. So this again is a very vague terminology. On a case-to-case basis, we have to see. Publicly available data is one for which processing is possible without consent. But normally, to be on the safer side, we say you can start processing, but when you want to go to the next stage of processing the data, you better take the consent so that you may use a search engine or something like that to collect the data, process it, make a listing. But then if you want to use that data for sending out any marketing information and so on, at the first available opportunity, you better take the consent. So, but at that time, the person may not come back and say, why did you at all take my information from my LinkedIn or something like that? That is the public information which I can collect and have one level of processing without consent. The second level of processing, if I can avoid, to that extent, I will be in compliance with the Act. Small entities is available only for manual processing. In India, we don't have many manual processing, even in smaller companies because of the GST. So this is not very much available. Now, cross-border transfer, Indian law is very liberal at the current stage, that is the 2019 PDPV version. Personal data, there is no restriction, it can be transferred. Sensitive personal data, there is some restriction. One copy has to be kept in India and explicit consent has to be taken. Critical data, generally not supposed to be transferred, but in emergencies, it can be transferred. Compared to this, GDPR has a very strict regime of data transfer, bordering on being considered as data localization. Today, if anybody asks you, data localization is there in GDPR, it is not there in Indian law. Accountability of data fiduciary is something which is a responsibility of the CISO or the DPO. That is, it has to take into account privacy by design, transparency in processing, security safeguards, data breach notification, conducting data protection impact assessments, maintenance of records, and having a data protection officer, grievance redressal mechanism, and so on. So this is something which we'll leave for the time being for greater discussion on a later date. But responsibilities of DPO is very interesting to note that he has to actually monitor the data processing activities of the entire organization. This is the reason why we say DPO should be at the highest level. He has to maintain records, which is record keeping. But while monitoring, he has to provide information and advice to the company about the legal situation. He has to provide advice to the company on the DPIA, data protection impact assessment. He has to provide advice on the PBD policy. So this giving advice means that the DPO will be poking his nose on every aspect of business of a vice president business, vice president technology, or whatever is that. That is why it is necessary for DPO to be at the very highest level. And that person will also be acting as a point of contact for data principals who are external persons. He will also be providing assistance to data protection authority. Therefore, he has to be above all the other people, because while dealing with DPA, this person's loyalty gets, to some extent, we can debate, this person gets the salary from this company, but he is responsible to protect the privacy of the public, and as per the law determined by DPA. It is like this role of a company secretary or the chartered accountants firms, where the liability of the DPO is to actually take the general interest of public into consideration. Okay. So the other point which I want to make again and again is that PDPA is different from GDPR. Compliance to GDPR compliance to ISO 27701 is not sufficient to be compliant with the PDPA. One has to forget the other things and relearn for the various reasons. One is data fiduciary as a concept is different. Classification of significant data fiduciary is different. Privacy by design policy to be submitted as a policy is different. Consent management system is different. Social media intermediary, sandbox, DPO. So there are a number of things which are different. So don't go by the same thing which GDPR has stated. This is the reason why I say that if somebody has a certification in GDPR by saying that I have a CIPP certification, I don't consider it as sufficient to be a DPO in the Indian scenario with the PDPA. And so this being the situation, we at FDPPA have responded in a different way, in a sense that we are creating a new path of how organizations have to respond to FDPPA, to the PDPA. So there are three important things which FDPPA has been doing, as some of you are aware, whoever has dealt with FDPPA. CDPP certification is there. As I was telling, today is the day when 24 people have completed module A, that is a data audit, and many of them would be also persons who have completed module I and module G. So they represent in India today a stock of data protection professionals with unparalleled skills on data protection compared to anybody else with any kind of certification from any global entity. If you are looking at the actual requirement in India, it is easy to acquire certification, but whether certification is relevant or not is issued. For getting these three certifications, people have sat through nearly 55 hours of classroom teaching, of course, online. They have studied more than 1,000 pages of documentation, and they have attempted examination for nearly 4.5 hours. So that much of effort has gone through a person who has been certified today in 3 modules. That is one of the things which we are doing. PDPSI framework is the actual framework for reference both by the organizations as well as for the implementing consultants and the auditors. We are also working on DDMAC, which is the mediation and arbitration center online for data related disputes. These are the 3 very important requirements for developing the Indian data protection ecosystem to meet the requirements of the world. As I have told you, module I on Indian laws, module G on global laws, module A on data audit are 3 modules which we have completed now. And then we are planning to have a module T on technology and module B on behavioral skills. Whoever completes all the 5 modules will really be a rare breed of data protection professionals. PDPSI can be used by the organization for self-implementation. They can use a consultant, and persons who are like lead consultants for PDPSI are being developed through our certification programs. Then there will always be auditors who will be using the PDPSI framework. So for these 3 different purposes, there will be the use of PDPSI. So there will be a lead PDPSI auditors, and the DPO will and the other consultants will work on the implementation. And in the process of this evaluation, we will also develop the DTS. Presently, the current version of PDPSI has got 12 standards and 50 specifications, details of which are available in our website. And PDPSI is considered as a unified framework with common controls for all kinds of personal data protection, with some specialization for India controls, GDPR controls, and Singapore controls. DTS is relevant today only for the Indian controls, but one unified framework for multiple data protection law compliance is what we are trying to work on. These are the details which those of you who are interested can go through. DDMAC, as I told you, is a ODR mechanism. We suppose this, see, every organization will be mandatorily required to have a mechanism for grievance redressal between the data principal and the company. Therefore, we are envisaging that there is an urgent need of a ODR mechanism to be adopted by the companies. This will also be useful for the companies for any other employee-oriented dispute resolution or business-oriented dispute resolution, and we are trying to give a platform for this particular purpose. I think I've taken whatever time I wanted to take, but I want to make a mention of only two important case laws which you must remember. One is that this, of course, both are from the GDPR scenario. PwC was fined 150,000 euros from the Greek authority. The reason was that the consent obtained from the employees for processing of the employees' information, the authority felt was not complete and adequate. Consent was there, but the data was being processed for purposes other than the purposes which were directly described in the consent. So they felt that transparency was not adequate. So the company was fined 150,000 US dollars, euros. And in giving this, the Greek supervisory authority did say US law is different, etc., etc. This is more like disputing the free consent mechanism. That is, they said that the employee was not aware what are all the purposes for which his consent would be used. Fortunately, Indian law appears to provide some kind of an exemption from consent for various issues. So we should not have this particular problem. GDPR, the problem is that consent is only one of the several types of legal basis for processing, whereas in India, consent is the only basis for which it is required of processing. And that consent has to be a free consent, similar to what we use in Indian Contract Act. So maybe this kind of a case will not arise in India. But when you say a free consent, we are talking of no threats, undue influence, contractual incapacity, misrepresentation, or mistake of fact. These are some of the things which you have to ensure that are taken into account when in your employee contracts. The other case which people in the HR department should remember is there was a case in the Belgian Data Protection Authority which said that a company which had designated a chief compliance officer also as a DPO was not properly avoiding the conflict. They felt there was a conflict of interest between the DPO's role and the CCO, so the roles should not have been combined. So this again gives some thought process to you to think whether you can have the CISO as the DPO also or something like that. Ideally, DPO is a different designation. He should not have many of these additional responsibilities. The problem in India is that you cannot appoint an outsider as a DPO. You have to have an employee. If you are having an employee, then you have to give him some work other than the DPO. Anything you give will be in conflict with the DPO's function. So this is a big challenge which the HR people have to sort out. If you don't want to have a unique DPO, if you can have a unique DPO, don't give him anything else, then it's fine. It can be possible for larger organizations. In smaller organizations, how to handle this is a tough challenge. You need to think more about that. So with this, I would like to close the discussion, and particularly those of you who are not from our normal FDPPA batch, if you have got any questions, please do let me know. And all the FDPPA people, I would expect you to do this kind of a presentation to your internal people. And perhaps that is the way we can spread the word about FDPPA activities. Then in the HR circles, people will realize what is the role of FDPPA, the role of these certifications. That is part of our responsibility. Okay? Yeah. Any questions?
Any question, anyone of you? To unmute and then ask questions.
Okay. So of course, FDPPA people should not have any doubts. That's a different thing because they are all experts by this time. But Reena has told that they have stopped
Yeah.
this NASCOM reporting. I don't know whether NASCOM has really acknowledged that they are discontinuing that practice. It is better they do it. Otherwise, remember, NASCOM itself will be a data fiduciary under the Indian Act. So people can question NASCOM if they don't properly secure the information, get consent, etc. Yeah.
Reena also has got one more question, Navi sir.
Yeah.
How
Yeah.
do we start engaging on this? Shall we create a business plan and a high-level gap analysis, then get the departments to engage? Approach.
Yeah, that is for PDPV.
Yeah, implementation.
Yeah, definitely. As of now, you can say gap is 100% because nobody has started anything. There is not a single, let us say, I'm talking of the basic thing. If a company has not deliberated the upcoming PDPV, okay, whether it comes after 3 months, after 1 year, doesn't matter. But the fact is that PDPV is coming. Now, a responsible board should pass at least one board resolution saying that we take note that Indian Parliament is likely to pass this in a short time. Therefore, we need to set up a team for looking at what are our gaps and then take up implementation. So I think it should start at that. That is what perhaps you call it as high-level gap analysis. And then if you have not started even classifying the information as personal data of Indian citizens, then you are at the zero end of the whole gap. From there, you start one by one implementing, and then perhaps you will know that there is a gap, and then look at how to implement it. Okay. If you follow the PDPSI framework, I think you will be able to find out how we can proceed with this identification. Yeah. Anybody else wants to add to what I said from your industry experience? You are welcome. Starting an engagement. Who has to start this engagement? Now, if you have already got a DPO, you will have to start it because he is presently DPO to EU, but he can start it. Otherwise, any responsible person, he could be the HR person. Now, maybe the HR person should start the engagement because he should worry about recruiting a good person as a DPO. So he has to bring it to the notice of the organization that we need to issue a employment requirement for DPOs, this thing, and maybe that will be the starting point. What do you say, Reena? So more responsibility for HR.
Yes, sir. Yes, I think I agree with your views. Only that I was coming from a point where since the organization is already GDPR aligned, so then the journey becomes a little more easy in the sense of bringing the gaps between GDPR and Indian PDPV. But approach remains the same.
Provided you recognize the differences.
Yes, yes, sure. Yes.
Yeah. Satish, Dvibashi, you have got anything to add? Your experience? And of course, Prakash. Okay, if there is no other questions, Ramesh, yeah?
Yeah. Anil
Yeah,
here.
Yeah.
Considering that Indian PDPA says DPO should be a kind of exclusive responsibility and should be the employee of the organization, looking at say small and medium enterprise who probably will not be able to afford a full-time DPO, do we envisage any change or any amendment in the bill which allows the DPO to share some role or a contractual kind of a DPO?
Say, presently what the act says is that he should be an employee.
Correct,
and he should be local. Okay. Then I am saying separately we are talking of conflict, and the two together indicate that it is difficult to give him any other conflicting role, which could be the technology role or whatever is that, because CTO is implementing the infrastructure and he will likely to compromise on any problems which may come, kind of a thing. So in a smaller organization, this definitely is an issue. we have ourselves suggested this to the JPC that you might have to look at this separately. I don't know, it may come. If it comes, it is fine. If it doesn't come, this problem will remain. But non-conflicting business responsibilities, you have to think of what exactly it means. Maybe in India, the compliance officer or the legal counsel, if he is she is also given this DPO, I personally would feel that that is not bad. Okay, because legal requirement and Pdpv is, I don't see much of conflict. The Belgian authority had its own views. I don't fully agree with it. So probably the first choice could be the legal department. But in many other cases, we have said HR is also suitable for this, for the reason that any privacy issue will immediately affect the individual. Some employee will be dissatisfied, so there will be a HR issue. So between the HR and the CCO, smaller organizations may have to decide. But don't try to give it to the CTO or CISO, because there the conflict will be more visible. My thoughts.
Right.
Okay.
Right.
Yeah.
If at all there is an option of having a contractual DPO, then probably FDPPI could also have a good bank of people who can get benefited as a contractual DPOs.
True, definitely.
Absolutely.
See, we are actually creating persons who can be data auditors. You know that every organization has to have a mandatory annual data audit by an external auditor, and our trained persons will be well suited for that role. Of course, if you are a data auditor for one company, you cannot be a DPO for the same company. Obvious.
Yes,
Okay.
correct.